just like the look of that baby's face. You know, it's like, and by the way, this is your average lawyer and judge too. When you come into them with an e-discovery, be prepared for this and just be patient in explaining it. I'll tell you one good piece of advice though: don't come off smart aleck, or they're really going to get pissed because they know you know it, and it's just going to create all kinds of bad things. Particularly if you're trying to explain to a senior partner or something, you got to be cagey and diplomatic to explain things to them, because it may be the only area you know more than them. So you got to just be careful in how you approach this. Big problem that perplexes all of us is there's too much information. It's a needle in a haystack, and this is what you're going to be struggling in e-discovery. I'm struggling to do, and that is shrink it down to the smaller size haystack. That's the fundamental challenge, really, of e-discovery. Okay, why do we learn it? Because that's where the evidence is, basically. We need to preserve evidence because this evidence throws itself away. And we need to find it in the haystack. Second, we're ethically forced to. We have a duty of competence to know where the evidence is and to find it. That's just part of being a lawyer. And he said, well, I didn't sign up to be an IT tech. Sorry, the world has become an IT world. We're in a technology world. That's how our clients now keep things and file things, is in computers. We are experts in evidence. We are experts in finding the evidence, collecting it without changing it, and getting it into a courtroom. Therefore, since the evidence is now digital and electronic, we must be expert enough in the digital electronic world to do this, to collect it. It just comes with the territory. A lot of lawyers don't like that, but that's just the reality. That's particularly if you're going to go into dispute resolution. It is critical that you know how to deal with your client's computer systems, understand their computer systems, and I'm telling you, it's going to be a challenge, because it's nothing like you're dealing with your individual systems. It is on a big companies are so incredibly complicated. If you're dealing with 3,000, 4,000 employees or 30,000 employees, something like that, all over the world, it gets very complicated to understand where the evidence is stored. And that's though something that if you're going to be a person that purports to resolve disputes by presenting evidence to the court, you have an ethical duty to learn enough to get that evidence into the courtroom and to find it. So it's not discretionary, it's just something you have to do to be a trial lawyer. And you need to do it to manage your risk. If you're a litigant, you need to make sure that, that you're not making too many mistakes. There's no such thing as a perfect lawsuit. It's just what side makes fewer mistakes. Plus it helps what side does in fact have the best facts on their side. But how are you going to know what facts are on your side unless you can discover them and see them? Not all email in your client's computers are going to harm them. Some of them may be tremendously helpful to you. Same thing, on both sides. So you need to find out what it is, and you need to have competence in e-discovery in order to manage the number of mistakes that you make and the severity of the mistakes that you make. When you make mistakes, try and make them little mistakes and fix them as soon as you can when they come to your attention. That's what risk management is, trying to get a handle on that. And frankly, it's also law firm liability, because when lawyers make mistakes, law firms are frequently being sanctioned. This is the new trend. Malpractice hasn't happened yet. It's only a matter of time, though, before clients start suing lawyers who didn't know how to get evidence out of their computers and didn't properly present it. And I'm sure you'll be faced with that someday. Last big reason is you need to learn e-discovery because it's the way to win cases, because people are communicating primarily electronically, and even when they're, of course, communicating by phone, that all then becomes something where there may be no record of it, and it becomes the, my justice formula I wrote about. I talked about how unreliable testimony is. When you get people testifying about what happened, it becomes then memory, and it's self-serving, and so they can distort and slant the facts. But when you show them something they wrote 3 years ago, they wrote it. then it becomes, whoa, it becomes a real dance for them to try and twist what they wrote. And so forever, the law has used written documents in order to keep the witnesses honest and to really get at what happened. It's not just what people say happened, it's what did they write at the time to give you the best indication for what happened. And that's how you then go to win cases. You may occasionally have a Perry Mason moment where you ask a person a question and they go, oh, damn it, you're right, and they admit everything. In my world, I've never seen that happen, though. This doesn't happen. People are dance around in depositions, but I have seen plenty of times the smoking gun document. Look at this. There's no way around it. Okay.